I call this meeting to order. Good morning and welcome to the fourth meeting of the Senate Finance and Appropriations Public Safety Subcommittee. Today, the subcommittee will review bills that require a Woodrum amendment in the budget. The Code of Virginia requires a deposit into the Corrections Special Reserve Fund when there is a potential increase in the number of prison beds needed. The Woodrum bill will be here today. Each required a deposit of $50,000 from the general fund, the amount required for an independent impact. The committee will then review several bills related to cannabis legalization in Virginia. Last year, the General Assembly passed legislation legalizing the simple possession of marijuana and establishing a process for individuals with certain marijuana convictions to modify their criminal sentence and have their sentence records sealed from public view. The legislation also established the Cannabis Control Authority to oversee a legal market for cannabis sales, set to begin in 2024. Aspects of the bill are subject to reenactment in this year's General Assembly session. The introduced budget includes $33.6 million for the Cannabis Control Authority to begin operation, including $6 million in fiscal year 2024 to provide loan funds for social equity licensees. I would also remind members of the public that we will be taking in-person testimonies during this meeting, but remarks should be limited to the fiscal impact of the bill. Before we begin hearing on the bills, the pages of the bill, we ask the staff to call the roll.
Senator Lucas?
Aye.
Senator Norman? Senator Ruff?
Here.
Senator Edwards?
Here.
Senator Peterson?
Yes, ma'am.
Senator Marsden? And Senator Evans?
Here. We're going to go by the sign-up sheet that a staff has. So who would be the first speaker this morning?
Senator Servo.
Senator Servo, you are first.
Can I ask an opening question to Servo, Madam Chair? Who hit the walk-off jumper last night in the gym to win the game?
You did, because you weren't covered very well.
There you go, exactly. Sorry, Madam Chair.
I knew you would.
You want me to use the mic?
Yes, it would be good if you did. Yes. We want you to be heard by the public.
Which bill are we doing first?
It looks like, well, you have, why don't you do 745 first?
745,
I'm sorry, 249 first.
249. Okay, Senate Bill 249 has to do with modernizing our bestiality law. Right now, our current law, when it comes to bestiality, only relates to when somebody has, let's say, intercourse with an animal, and carnal knowledge. Fair point. And this statute basically broadens it to people who supply the animal, people who sort of make an animal available or sell animals for purposes of sexual contact. It also makes it illegal to possess pornography that reflects bestiality. And this has been done in many other states. The Humane Society asked me to carry this. There's a strong connection between child pornography and child sexual abuse and bestiality, and I can get into the stats if you really want me to, but it's not a very pleasant subject.
And I think we've heard enough of that anyway.
That's basically what it does.
So what we're creating a class, I'm sorry, Madam Chair, if I might ask a question.
Senator Peterson?
You're creating a Class 6 felony, Scott? What are you changing here?
Well, it broadens the class of conduct that is criminalized and makes it a Class 6 felony. Right now, it's not illegal to
pimp a pet?
or to have videos or picture depictions of that. And at subcommittee, we took testimony from some detectives who talked about what they discover and what they can't prosecute and how often they find it. And there's a lot of research that shows a strong correlation. And I mean, I can get into the details if you really want to, but it's not pleasant stuff.
Well, we're here primarily to deal with the fiscal impact of the bill anyway, so
Right.
we're going to go right straight for that.
Madam Chair?
Senator Evans?
So I noticed it came out of Ag, I think 11-1, and it has a
Judiciary.
minimal. Oh, Judiciary, I'm sorry.
We referred it.
Oh, Judiciary 14-0, and it has a minimal fiscal impact, so if it's appropriate, I would move that we report.
Second.
It's been moved and seconded that the bill be reported. Any statement from staff?
No, Madam Chair.
Okay. It's been moved and seconded that the bill be reported. All in favor, please designate by saying aye.
Aye.
Okay, Senator Servo,
Thanks. What's the next one?
745. Or either 742, whatever your preference.
Let's do 742. That's the expungement bill.
Yes, it is.
Or rather, it's probably this. Anyway, this bill basically does 4 sort of cleanup measures on the legislation we passed last year. Number one, we last year with the governor's amendments to the marijuana legislation, he added automatic. He called it automatic expungement of convictions, when in reality it was automatic sealing. This changes the terminology from automatic expungement to automatic sealing, so it's consistent with sealing, because right now it basically creates a lot of confusion. It creates expungement, sealing, and automatic expungement, which is
So you're
really
just making
simple.
them consistent.
That's what the first thing it does. The second thing it does, it requires expungement petitions to be sealed. The third thing it does is it makes expungement petitions subject to civil liability, just like sealing is. The fourth thing it does, which you probably care about on this committee, is it makes the court-appointed attorney fund available for expungement petitions. Right now, it's only available for sealing petitions, and so it makes it available for both. It basically makes expungement and sealing the same, which I thought was what our intent was when we passed the expungement legislation and sealing legislation last year.
Any questions of the patron? You've heard the motion. I'm waiting for a second.
Second, I'm sorry, second.
It's been moved and seconded that the bill be reported. All in favor of that motion, designate aye or nay.
Aye.
We have one nay.
Frank, we're up, yeah.
Thank you.
Third
Senator
is
Servo,
746.
745.
No, 45. And Madam Chairman, this bill is a combination of your bill and my bill.
Yes.
And this has to do with people who are currently imprisoned for either marijuana convictions or situations where people had their sentence enhanced on a different charge for by a pre-existing marijuana conviction. And basically it says for anybody who's incarcerated for marijuana distribution, they can apply for resentencing with the judge they're in front of. If they had a sentencing enhancement for a marijuana conviction, they can apply to the parole board, which is how we handled Fishback. And so that's basically what the bill does. It's my anticipation, by the way, if this was favorably received by the body, that it'll get incorporated into the big marijuana bill.
That is correct. Any questions of the patron?
Report.
It's been moved and seconded that the bill be reported. All in favor of that motion, please say aye. Nays have the same right. One nay.
Okay, thank you.
Thank you, Senator Servo. Patron signed up. Senator Peake.
Good morning,
Good morning.
Madam Chair, members of the committee. This
You
is-
have one bill, and that is Senate Bill 174,
Yes, ma'am. And
protective orders.
I have no idea why I'm here. It has zero fiscal impact. The fiscal impact statement says it has zero fiscal impact, but here I am. This is a,
Staff,
Madam Chair, there has been an issue raised with the Violence Against Women Act, whether or not the language would affect the funding from the federal government as it relates to those Violence Against Women Act.
but it was not raised by anyone in any position of any financial, I mean, it was correct?
I would defer to finance then for that.
Madam Chair,
Senator
I
Peterson.
recall having a hearing on this in courts. Can you just recollect to
Yeah.
me what this bill did?
This
Mark?
bill makes it an affirmative defense if you violate a protective order, if they called you or came by and you spoke to them or returned their call, or if they
Oh,
sent you an email and you email, respond, or text back to them, it's an affirmative defense that they contacted you and encourage you to call them back. It does nothing. I think that somebody out there sent a letter saying it was creating a reverse protective order. That is absolutely not true. It puts no obligations on the person who requested the protective order. It doesn't prohibit the person who gets the protective order from contacting anyone or the respondent that they're getting it against. All this order does is say, if the person who got the protective order initiates or instigates contact with the person they got it against, and they respond with a phone call, they can use that as a defense. Because right now, if you violate a protective order, it's automatic jail time. They have no choice, if you violate a protective order, but to give you jail time. And there's no affirmative defense. Now, if they do it, you can say, she called me and asked me to pick up the kids. I texted her back, said, okay, I'll pick up the kids. That's not a violation, because that's my defense to the violation. I was responding. Now, but it's just an affirmative defense. If she texts you and says, will you pick up the kids, you text her back 20 times, that's going to be a violation. So in any event, it has no fiscal impact from the Violence Against Women Act because it does not put any obligations whatsoever on the petitioner.
Madam Chair, I was just going to point out that the introduced version did have a woodland
Yes.
impact, which may be why Finance flagged it. The substitute, which was adopted in Judiciary, removed those provisions which created the woodroom, the necessity for a
Correct.
woodroom impact.
The initial drawing put some prohibitions on the petitioner. The way we came out, and we had amended it before we even went to Judiciary, it absolutely has no reciprocity on the
I don't see
petitioner.
how this is,
Report.
yeah, second. I don't see how this is.
need to adopt.
Oh.
No, sorry.
Can I get a motion on the amendment?
Move to adopt.
Second.
It's been moved.
And what the amendment
Second.
does
Hold
is-
on a second.
I'm sorry.
Can we all vote on the amendment? All in favor, say aye.
Aye.
Nay, same right. Okay, now Senator Peake.
Madam Chair, the amendment just puts it in the criminal code that it's an affirmative defense. So now it's not even in the protective order stat part of the code. So it's clear that it has no reciprocity, doesn't create some kind of protective order.
Madam Chair,
Sen-
I got a question.
Senator Edwards.
Isn't it a fact, though, you could still raise this as an issue in defense, whether you call it an affirmative defense or whatever, that I didn't intend to violate anything, Judge?
No,
You can
because
still do that.
you contacted them. You violated the protective order. It says no contact of any kind.
But you can still, when it comes to intent, you can always raise this kind of issue.
Well, the intent is. Well, you've got a text from your phone contacting them. You violated it.
Senator Peterson.
Okay, now I do have a minimal comment. I'm looking at lines 41 through 44, and I voted for this. I think you want to have the word solely, so the respondent subsequently violated a condition imposed on him solely as a result of such invitation or solicitation. In other words,
Yes.
if you go to your ex-wife's house and you
Absolutely.
raise a rambunctious, I would move that amendment.
Second.
Thanks.
Been moved in second
Edward Sol.
about the land amendment. All in favor?
Aye.
All right. Senator Peake.
And I would just say, in response to Senator Edwards, if you've done these things, if you've been in court, the judge says, my hands are tied, you violated it, you get a day, and they don't have any choice but to give you a day in jail.
Senator Edwards.
My objection is, in any kind of criminal case, you can always raise the intent, okay? It says, Judge, I only did it in connection with X, Y, and Z. And you can always raise these kind of defenses. And I don't think you need the bill, and I think it could have some perverse impact.
Madam Chair, I'll make a motion.
Senator Peterson.
I'm going to disagree with my colleague. I actually think it's a pretty good idea, and I just think it's giving guidance to the court, so I'll move to report.
Second.
It's been moved and second that the bill be reported.
Madam Chair, we may have folks in the audience to do testimony at some point.
Oh, that's right. We're gonna have testimony. I'm sorry. Would you please come? You speaking in favor of the bill?
In a weird place, in opposition possibly.
Okay, that's okay. Come on, have a seat.
It
Okay.
means that there have been many substitutes.
Okay, could you turn the mic? We want to make sure that you're heard.
Madam Chair, Jonathan Iglesias. Madam Chair, members of the committee, Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. We had very strong opposition to the original bill for the exact reasons that Senator Edwards brought up. And it was, in its original form, a reciprocal no contact order, which is in violation of federal funding. So the question that we've had with our federal funders is whether or not we have to sign assurances to accept these federal dollars in Virginia, about $50 million from the Violence Against Women Act. And the question was whether or not this would jeopardize that funding. We're still getting, yep.
Well, let me ask you,
Senator Peterson.
at this point, with the text, it would be simply, if you have a no-contact order, say with an ex-spouse or an ex-girlfriend or an ex-boyfriend, and they text you and say, come on over and pick up Johnny or little Susie, and they come over and pick them up, and they're like, oh, you violated protective order, you would agree with me that that's what this situation is addressing.
I would agree
When
with
I
you,
add
yes,
the word
Senator.
solely. So if there's an incident afterwards, that's not protected, but just the solely if upon invitation.
So we are still in conversation, Madam Chair, Senator Peterson, we are still in conversation with our federal funders about whether or not it does have a chilling effect on victims. So that is one of the provisions or the assurances that we have to sign when we accept funding, is whether or not there are protective order laws in place that have a chilling effect on petitioners or victims seeking safety through the courts.
Senator Peterson.
I mean, sitting here in the court of common sense, I have a hard time. I mean, listen, just the language here, I think is common sense.
I understand.
So, anyways.
Thank you, Senator Peterson. And Madam Chair, I will say just another issue that was raised by our advocates statewide was this is something that's often used. To Senator Edwards' point, this is something that is often used. It's unnecessary, we believe. And we have abusers all the time who come forward and say, well, she texted me, she baited me, she XYZ. We believe that we have plenty of judges who already believe that line of questioning, who already believe that narrative, and have a hard time believing that petitioners are in need of safety. And
Sounds like
yeah.
a judge we need to replace now.
Senator Norman.
About that.
It's bills like this that remind me why I'm exiting the domestic relations business. Absent having something in writing, say.
Could you turn the mic to Senator Norman?
I'm sorry.
We want the public to hear every word he says.
Not really. Absent having something in writing like a text or email, it's still going to boil down to he said, she said, which these things revolve around in court all the time. The other thing that certainly occurs to me, I'm going to support it, but just from the court of common sense sits down here too. That last part of it, as it talks about as a result of such invitation or solicitation, they're going to try to raise it as a defense, but say, I didn't come as a result of that invitation or solicitation. That's what the spouse is going to say. But it's better than nothing.
If you've got to write a text or an email, it certainly will help.
Yeah, absolutely.
You have further testimony, sir?
Just, Madam Chair, the one thing I would just say is we see this used as a tool by abusers against victims all the time in the courts without the affirmative defense being there. And so we believe it will have a chilling effect, even if it's removed and put into this violations of protective order section. That is our worry. That is the advocates' worry. That is survivors' worry statewide. So we appreciate the time. Thank you for letting me testify.
Madam Chair?
Thank you so much. Senator Eben?
For Senator Peake, just to be clear, he just mentioned a text or an email, I guess, as evidence. But are you suggesting that under this bill that they would have to produce written evidence, a written invitation, or just would a verbal be still be a defense?
Madam Chair, I submit that in verbal, they're probably going to lose. But when you have text and phone calls these days where you can have the cell phones that show the number that came in, or if a text was sent, it's still, many judges find, you violated my order, which said absolutely no contact.
Further question?
And
Eben?
And I'm not an attorney, so I don't want to belabor this or get into the bill too much, but would you be amenable to saying if they were invited via email or text, so in other words, everyone would know that it had to be in writing?
well, I will say, well, no, because it can be a phone call, and then you can show that they called. First of all, they're under protective order, so they can't be in person. They can't be talking to this person. So it's got to be a phone call, and a phone call will show that a number came in. A text will show that a text was sent. An email will show that a text was sent. So, I mean, they can't be in person anyway.
Okay,
That's the way it's
because I would
gotta be.
support it if it was email or a text and that was the defense. But a phone call, you could be just saying, pick up your kid from school rather than come visit me.
Well, that's the whole point. If they call you and say, come pick up the kid, and then you call them back, they go to the court, and then they get mad at you 3 days later. They come to the court with their phone and say, this guy called me, and he is under an order that says no contact of any kind, but here he is, his phone number on my phone number.
I see. Thank you.
That's the point.
Madam Chair.
Senator
That's
Edwards, and then
judiciary,
we have another speaker.
There's no financial impact.
This is the problem with the General Assembly trying to get into the weeds of trying cases. This is why we have judges. And intent is always an issue in any kind of case. I think this has perverse effects, so I oppose the bill.
We have another speaker, ma'am. Would you join us at the table?
Good morning. Sushila Varkey on behalf of Virginia Poverty Law Center. I oppose this bill and have spoken to Senator Peake about it. The issue that we're not talking about is that original issue that Senator Peake brought this bill about is respondents being arrested when they violate a protective order by contacting the petitioner. This doesn't deal with that because it's an affirmative defense after the court has determined guilt or innocence. This is always an affirmative defense that a defendant can bring up. Why are we putting it in the code to clue in both respondents as well as judges that this is a way to continue to use the very tool that findings were made on to protect this petitioner, to continue to harass and manipulate her? No contact means no contact. The proper response to being arrested for this particular situation is to file a motion to dismiss the protective order, revise or amend it so you could contact each other. So I submit, as the prior witness mentioned, as well as Senator Edwards, that putting this in writing in our code in the violation statute is
Madam Chair.
inappropriate. And it also is going against the
Let's let her
trend.
finish first, please. Go ahead.
It's going against the trend of what states are doing. Most states, except for Arkansas, are establishing language that says even if petitioner invites, it is not a violation. So this doesn't address the original issue that Senator Peake brought this bill about. If there is contact, there's contact, and if that's part of the protective order, it's a violation. The judge has to determine guilt or innocence, and then the defendant can bring up their affirmative defense language and arguments. It shouldn't be in the code.
Thank you. Senator Peterson.
Madam Chair, this is a comment. I appreciate all this, but here's my concern. We had a very long hearing on this in Judiciary Committee, and we're now re-arguing it when a fiscal impact is zero. So if we're going to use finance to re-argue every single policy decision, we're going to be here till mid-April.
Well, can I
And
mention about the
ma'am,
fiscal
I'm not-
impact?
I'm not
Madam
soliciting
Chair?
your reaction to that. I'm telling
Yes.
you what I feel as a member
I
of this body.
understand, but I would submit, Madam Chair and Senator Peterson, that putting it in the code is actually increasing fiscal impact because more people are going to be using it as a defense if it's written right there for respondents to use.
Thank you. Do we have any other speakers speaking in favor or in opposition?
To wrap up, this will cut down fiscal impact because some people might not have to spend a day in jail unnecessarily.
We operate by motion?
We have a motion and a second report.
There's a motion and a second to report. Was that also with the with the amendment? Okay. All in favor of that motion, say aye.
Aye.
Noes have the same right? No.
No.
3 noes.
4-3.
Thank you, Madam Chair. Thank you, Charles.
Okay, Charles, who's next?
Senator Steph.
Senator Steph, you have one bill, Senate Bill 700.
Yes, ma'am. Madam Chair, members of the committee, I promise it's going to be much easier. I swear it's going to be super easy. So,
I believe you.
thank you. So what this bill does, and it's brought on behalf of our sheriff down in Virginia Beach, it says that if a prisoner obstructs or covers a video camera, and there's an offense, whether it's a rape, inmate on inmate, whether it's an assault on an officer, assault on someone else, then the person that covered the camera or is holding something over the camera is charged, if it's a misdemeanor, then charged with a misdemeanor. If it's a felony, then they're charged with a Class 6 felony. And it does have the Woodruff Amendment on there just because of that. And Madam Chair, I believe that, and members of the committee, I believe that this is one that tightens up the law and is definitely a necessary thing. And it came out of committee, I believe it was 14-0, maybe 15-0.
15-0.
Senator Eben.
Yeah, I like the spirit of the bill, and I just wanted to ask the patron, shouldn't it be anyone who covers the camera? If the camera, so it's, any person, so that includes, okay, great.
Yes, sir. Madam Chair. Anyone who covers it.
It's any person. Any other questions of the speaker? Motion? Been moved and properly seconded, the bill be reported. All in favor, say aye. Aye.
Madam Chair, members of the committee, thank you very much. I said it was going to be quick.
Thank you very much for that. Next on sign up, do we have any other patrons in the room? Okay. Senator McClellan, I meant patron who's not member of the committee. Okay, Senator McClellan?
Thank you, Madam Chair. I have Senate Bill 486.
486.
Which, as amended, makes clear that a petitioner seeking a preliminary protective order can include an employer. And that's the bill.
Madam Chair, we had a robust hearing on this in civil sub. I think it's fine, and I'd move to report.
Is there anyone in the audience like to speak in favor? We have somebody, okay, thank you, just for your, okay, there's been a motion,
A second. Down
and a
there.
second to report. All in favor, say aye.
Aye.
Aye. Thank you, Senator McClellan.
Thank you, Madam Chair.
Okay, now we will move to the members' bill. I don't see Senator Mason. Okay, Senator Eben, you're up.
Thank you, Madam Chair. If I could, I'd like to start with SB 643, which has to do with firearms that have had a serial number removed. And I believe that a substitute has been passed out to each member.
Let's get a motion on the substitute.
This bill enjoys the support of the Virginia Citizens Defense League, the NRA, the State Police Association, and several gun safety groups.
Are we dealing with the amendment?
Oh, I'm sorry.
I need a motion on the amendment.
Move the substitute.
Okay, the substitute, okay. All in favor of the substitute, say aye. Aye.
And the difference between the substitute is it makes it very clear that this does not apply to antique guns. In committee, there was an array of subcommittee support unanimously, but then I understand in full courts, I stepped out of the room and I understand there was some question about antique guns. What the bill does is it makes it a Class 6 felony to knowingly transfer any firearm whose serial number has been removed, altered, or destroyed. That's already a federal crime to deface, to take the serial number off, and it makes it a Class 1 misdemeanor to possess a firearm whose serial number has been removed, altered, or destroyed. Currently, Virginia law states it's a Class 1 misdemeanor to remove the serial number from the firearm, but you don't really catch people with the drills and the chisels removing the serial numbers. We've had some prosecutors recover guns from crime scenes with serial numbers removed, and they couldn't charge someone for possessing a gun where the serial number was intentionally defaced and removed. I think the bill is pretty self-explanatory. I had a little sheet. Really, it takes effort to remove the serial number. The guns are contraband guns, the crime guns. This is not the same as a ghost gun bill. This is for guns that once had a serial number on it.
Okay.
And then it was removed. And I think the array of supporters says something. Mr. Huggins from the State Police is here if there are technical questions or questions for him.
Any questions? How long have you been there?
Just walked in. Move to report. Second.
It's been moved and probably second that the bill be reported. All in favor, please say aye.
Aye. Gives me no votes.
Senator Evan, could we please suspend so we can deal with the issue of a non-committee member
An issue. I don't mean to be an issue, Madam Chair.
with a bill?
Thank you very much, ma'am.
I didn't see you walk by. I guess I was
Senate Bill
reading them.
687.
687.
Yes, ma'am. And the crux of why I'm here is, if you look on line 76 to 79, the definition of incapacitated adult. This is a VCJC recommendation cleaning up this portion of the code, and we expanded over to lines 89 to 94. We add developmental disability, And then at the end, or has one or more limitations that substantially impair the adult's ability to independently provide for his daily needs or safeguards his person, property, or legal interests. So that's the expansion of the change in the definition from incapacitated adult to vulnerable adult. Last year, there were 14 offenders convicted for a felony financial exploitation and 20 for abuse or neglect of an incapacitated adult. So those are the numbers we were working with last year. We expand the definition marginally. So if you took 50% of that, you'd have 21 and 30.
Okay, I need to turn to staff because we're not dealing with the substance of the bill, but the fiscal impact.
Yes.
Solely related to the expansion of definition.
Right. Yeah, sorry about that, ma'am. I was doing just that portion of the.
Okay,
So it's the expansion creates additional crime.
thank you for the explanation. Anyone present to speak in favor of the bill?
I have a question.
Senator Norman?
Is this in any way expanding the liability of banks or credit unions as to their liability on financial abuse to elders?
Madam Chairman, Senator Norman, a battle we've had each and every year, and no, sir. They're still asked to keep an eye out, but we have not added to, as we bring every year, putting them frontline reporter. So no, sir.
Thank you, sir.
Thank you, Mr.
Thank you.
Madam Chair.
Further questions of the patron on the bill, not an issue?
Move to report.
It's been moved and seconded that the bill be reported. All in favor, say aye.
Aye.
Thank you, Senator
Thank you,
Mason.
ma'am.
You're welcome. Back to you, Senator Eben.
Thank you, Madam Chair. If we could move on to cannabis. This is Senate Bill 313, which is what I call the transitional cannabis sales bill. As you remember, last year when we legalized marijuana, the bill that was reenacted said sales wouldn't begin until January 1st, 2024 through the Cannabis Control Authority. We have pharmaceutical providers right now who are capable of selling to adults 21 plus, and what the bill does is it allows them the substitute that came from rehab, allows the pharmaceutical processors to sell starting January 1st, 2023. They are required to have to educate consumers about responsible consumption of cannabis products, incubate up to 5 independent cannabis retailers for a period of 6 months, or support and educate persons that wish to participate in the cannabis market. There's a DEI plan required, but probably the only two fiscal changes to the bill. It adds a 3% local tax, as we put in the bill that we passed last year, and it also changes the fee for these pharmaceutical providers who are getting in the market early from $1 million to $6 million for that early advantage in the market. We are estimated to have the 4th largest illicit cannabis market in the nation, valued at over $1.8 billion in 2020 alone. And this is a way to start cutting down on that market, and also for people who want to buy the product to buy one that's been tested and is not laced with fentanyl or other
Pesticides.
dangerous drugs or pesticides. This is 313.
Any questions of the patron?
Madam Chair,
Senator Marsden.
thank you. There are also bills working through both the House and the Senate to do away with the permitting requirement of the Board of Pharmacy because it is legal, and right now they're backlogged by like 8,000 permits. They can't get them out the door, so hopefully that legislation will pass. And Senator Eben, if I could, is there a requirement here that in your bill that the needs of the medical patients is prioritized over that of a recreational user?
Yes, Madam Chair, it says, Senator Marsden, that it requires that they both maintain sufficient cash registers, but more importantly, sufficient inventory. So if they're going to fall short on inventory, the medical patients have to be served first.
Mm-hmm.
Thank you.
Further questions, Senator Marsden?
No, that's it.
Okay, sorry. Any further questions of the patron?
Madam
On
Chair.
Senate Bill 313, yes, ma'am.
Members of the committee,
Fiscal.
another thing to note just on the fiscal side is, Senator Urban, I believe The bill denotes the $6 million fee only to loans for social equity applicants, so just another thing to note.
Yeah, that's
about
where it's
that.
allocated to, yes.
Thank you, Madam
Okay,
Chair.
and is that the impact?
Yes, that's correct.
So with that,
Move to report.
Second.
it's been moved and properly second that the bill be reported. All in favor?
Aye.
Aye.
No.
No.
2 noes to my left.
You're abstaining.
Okay, and then the larger cannabis
Hold on
bill,
a second.
What's the vote count on that?
I think there is an abstention on this one.
4 yeas, 2 noes, 1 abstention. I'm just trying to find. I'm sorry.
Okay, so the next bill was SB 391. This is the larger omnibus cannabis bill. I prepared a guide because the bill was 198 pages as introduced. So what I did is I gave you a chart that's at your seat, and the changes from last year's bill are noted in the notes. They either came from the Northern Administration request as a cleanup or from the Cannabis Oversight Commission, which I chair, which is a body of 10 General Assembly members that studied some of the provisions. And some of our decisions were informed by the JLARC report that we added in the enactment clause, that JLARC would analyze last year's bill and see how close it was in keeping with JLARC's recommendations. I believe that we accepted all of JLARC's recommendations but one. And then I'll just walk through, if I might, Madam Chair, really briefly, some of the main points.
Yes. You
We
said it will
added
be
a-
brief, right?
Yes, and just tell me when you heard too much. I added penalties to the home grow section for not labeling your plants, because if there was no penalty, it would have reverted to a serious penalty, so it's just a $25 fine. We maintain the ability to enforce possession with intent to distribute marijuana past January 1st, 2024. It gives the Cannabis Control Authority regulation of all products with THC for human ingestion, such as Delta 8, 9, 10, those sorts of things. It transfers, it adds a marijuana testing lab expert to the Cannabis Public Health Advisory Council. It says the licenses are non-transferable. It allows governing bodies to adopt ordinances prohibiting public consumption on public school grounds. I limited the hours of operation. Last year's bill said that the localities could limit the hours of operation. I thought we should tighten that down, so say that you can't have any retail marijuana store open between 9 p.m. and 8 a.m. Further, the same $6 million fee is embedded in there, but a pharmaceutical processor would only pay one fee. They would, if they go early, they can pay the $6 million fee. If they choose, for some reason, to wait, they could pay to be vertically integrated, that $6 million fee to that same fund. Further, we put some advertising and marketing restrictions on to tighten it as much as we can. Under free speech and other federal guidelines, we say you can only advertise on radio and TV if at least 85% of the audience is presumed over 21. They can do that through ratings. It bans minor-friendly advertising techniques and untrue and unambiguous health statements. Bans contests or sweepstakes predicated on buying cannabis. And then the last thing I'll mention, Madam Chair, is that it requires the CCA to promulgate regulations by January 1st, 2023, rather than July 1st, 2023, so that those that are getting the market on 2024 will be able to.
Could you repeat that last part? Are you saying 2023 or 2024?
The regulations would be promulgated by January 1st, 2023, rather than July 1st, as it was in last year's bill. And also, in terms of resentencing and sealing and expungement, what we intend to do is there's some provisions there, but we were going to mirror exactly what came out of Senator Servel's and your legislation that's been vetted by courts.
Okay,
So that has not yet been inserted, but it will be inserted.
thank you. If I'm not mistaken, I think Senator Peterson?
I don't have a question.
Okay, all right.
I have
Senator
a
Senator
question.
Edwards, okay,
There's
just,
some people from my district that said that 21% excise tax was too high, they'd be defeated, the black market would undercut them.
That was what we codified last year. However, JLARC noted in the report that there is such a thing as too high a tax competing with the black market. The House version has a 10% tax, and I think when this goes to conference, we may well revisit the tax rate. But right now, the tax is in the Code of Virginia. That part was not subject to reenactment. But we are open to, as we go through negotiations, to either a lower tax rate or a lower tax rate to start that escalates over time. But we don't want to end up like Washington State with a 30% tax rate.
Right. Senator Norman. I'll turn my mic.
I still stand by what I said last year. This is one of the worst written pieces of legislation I've seen in my career. And part of it is because it attempts to be so universal and omnibus and incorporates so many diverse topics where it really ought to be individually addressed. But having said that, I'm looking at the distribution of net profits, and I see 35% to substance use prevention and treatment. I've asked repeatedly of Senate finance staff and others, we are putting tremendous amount of monies into community service boards and other things for drug treatment. And my question repeatedly has been, what is the population that we're serving? Are we in fact creating a monstrous bureaucracy with lots of revenues where they really have not identified a significant percentage of the population? And you look at lottery, you hear about lottery, and some of that money goes in. And so I see that 35% of the distribution of the net profits is going into this. And my question is it going to be more than a tagline on a radio or TV advertisement, call 1-800 if you have a problem?
Yes. Well, first off, that's codified for last year, so that, I believe that language is not in italics in what you're pulling up, if I'm not mistaken. Is that correct, David?
That section is not in the bill. The allocation of revenue is not.
Yeah, that was last year's bill. But just so to answer the question nonetheless, the intent was that it would go through Community Services Board for substance abuse treatment, and give them some flexibility in how they use those funds. But it doesn't have to be for, there's people debate this, whether or not people abuse marijuana to the point of needing rehab, but they can be used for things like opioids or other substances, but it does provide a dedicated revenue stream for that. Happy to talk to you further about it offline.
Senator Peterson.
And Senator Evan and I have talked offline about this. I've never been a big fan of the whole commercialization concept, but can you talk about teenage use, and does your bill address that, and how does it address that?
I'm going to ask Mr. May to help me, but I would say that it doesn't allow sale for anyone under 21. The penalties remain for giving, for transferring or selling. You would lose your license if you sold to someone under 20, but if you're just an adult who buys it at a store and gives it to a kid, right, that's a crime. That doesn't change.
And is that a misdemeanor? Is it distribution? What would it be?
I believe right now for sale, it was a mandatory minimum of 10 years in jail. I removed some of the mandatory minimums. I met someone in Virginia, maybe I'm wrong, who spent 10. I recently met a gentleman who was 18 years old in college, and he sold to a 17-year-old fellow college student and told me that he spent 10 years in jail for that. But that's not the same as, I don't know if Mr. Mayor or Mr. Quagliato could give you the exact penalty.
Madam Chair, can I ask?
Senator Peterson.
So if someone sells to a minor, someone who's, say, 16 or 17 years old, what's the current penalty under code, and is that changing under Senator Evans' bill? That's my question.
Unbelievable. They pay no taxes for 30 years.
If there was a mandatory minimum, I believe we removed the mandatory minimum, but remained the penalty. But I don't expect the mandatory minimums to make it through the other side of the building, that piece.
Do you know the answer?
Neither do I.
Tom, do you know the answer?
No sales tax.
We're not changing the penalty, I know that.
What's for selling marijuana to an underage, we're giving, what's the criminal penalty right now? I assume it's against the law.
It is against the law, and it's even a felony to sell THC currently under current law.
Okay, Class 6 felony? I mean, what?
I don't know, I'm sorry, I don't know the class.
Does-
I don't know the class, but it is a felony.
Cereal bar.
Is it against the law to sell it in cereal?
So,
Well, eat to a child, that, I think that would be, definitely would be a felony.
So, Madam Chair, currently, to distribute marijuana to any person under the age of 18 who is at least 3 years his junior, so
Right.
there's an age difference, shall be convicted upon imprisonment in a state correctional facility for a period of not less than 10 nor more than 50 years.
You are right.
And
I am
fined not
wrong.
more than $500,000.
Yeah, and I met a gentleman who spent 10 years doing that, and he must not have been 18, he must have been 21, selling it to a 17-year-old college classmate.
5 years of the sentence imposed shall be a mandatory minimum for 1 ounce or more of marijuana.
Okay, that's a great, why we don't need mandatory minimums. By the way, I'm wrong, Adam's right, so thank you, Adam.
I will put that on my CLE. So the bill, just to summarize, Madam Chair, the bill, the changes from last year's bill are highlighted in this chart. They've come from largely JLARC, the Cannabis Control, from JLARC or from the Cannabis Oversight Commission, or in a few cases from the Rehab Committee, made a change or two. But I hope that this guide is helpful. If anyone finds anything on it,
It is helpful.
Further questions, my office is happy to update it.
Anyone in the audience would like to speak in favor of the bill or in opposition? Yes, please.
My name is Tom Torcio, and I'm
Okay, let us turn the mic to you so we can hear you.
First of all, good morning, Madam Chair and
morning.
members. My name is Tom Torcio, and I'm with the Virginia Catholic Conference, and I also represent Virginians evaluating drug legislation. And we're an organization comprised of health practitioners, prevention specialists, educators, and concerned community advocates throughout the Commonwealth. I have just, this is a money committee, I know that, and we're talking about fiscal impact. So I just have a few numbers to share with you today, and I'm just going to use those numbers as a reference point for the fiscal impact of Senator Evans' bill. The first number is, in looking at California, $100 million. In 2016, Californian voters approved legalization and commercialization of marijuana. In 2021, the General Assembly there had to appropriate $100 million to bail out their legal commercial marijuana industry because it was failing so bad it was on the brink of bankruptcy because it's being outgunned and outperformed by the illicit market. So that's one number, 100 million. Another number that I'd like to reference is $1. For every dollar in tax revenue that the Commonwealth will take in from cannabis taxes that we're talking about today, the Commonwealth will pay $4.50. So the ratio is for every dollar you take in on tax revenue, the Commonwealth will have to pay $4.50 for the law enforcement and social costs that result from commercialization. That is borne out by a study by the Centennial Institute in Colorado. As you know, Colorado's had legal commercial marijuana since 2013. That was their effective date. So those are two numbers that two numbers I want to share with you. The last one is somewhat of an indeterminate number, and that is that the social costs and the law enforcement costs associated with drivers who are operating under the influence associated with cannabis, marijuana, high-potency THC. And this is something that is so critical. We do not know the cost associated with high-potency THC and the impact that it will have on drivers, because the New England Journal of Medicine last month released a study, I'm holding it up right here, that documents what has been shown in Washington State and Colorado, that when you put a multinational, multi-million-dollar marketing campaign behind THC, high-potency THC, it results in a double of fatal car collisions, fatal car crashes, and fatalities. That's been borne out in Washington State, Colorado, and this study with the New England Journal of Medicine documented that in British Columbia, in Canada. It's in the New England Journal of Medicine. I have the document right here. We don't know the human cost that is going to bear, that's going to bring to bear on the Commonwealth. It's an enormous cost, and we don't want to impose that on law enforcement. We know that crime goes up. Statistically, every time you introduce a pot shop, for lack of a better term, in a neighborhood, crime, especially property crime, goes up in that area within a 1 mile radius. So there are documented studies and surveys that have been done that show this is borne out. So with that, those are a few of the numbers, and for that reason, we would respectfully ask that this subcommittee reject this bill. Thank you.
Any questions of the speaker?
Madam Chair, if it's not too much trouble, sir, I'd love it if you could give me a copy of that study from the Centennial Institute or a link or something.
Absolutely, sir. I sure will.
Please join us.
Madam Chairwoman, members of the subcommittee, Todd Gackey on behalf of the Family Foundation. And I won't duplicate what the gentleman has already said. Many of the same issues have been raised and our concerns. We're concerned about the families. We're concerned about what the impact will be on our communities. And so let me speak to just the forecasting component of this, which is that the Oregon's Office of Economic Analysis found in 2017 how difficult it is to forecast the revenue that's coming in from this. I know there was discussion about the tax percentage and what is the appropriate tax percentage to use, but you have to have data, you have to have historical data on demographics, on usage, on product types, and we just don't have that kind of information. Alaska's found through, if you go through public polling, trying to find out usage, and maybe those that have used are just forgotten, I don't know, but how do you get that reliable data? And a lot of it's undercut by also the black market, as was mentioned. Lastly, I'll just kind of mention, what are we investing in? Here we're trying to legalize it, but at the what you're going to promote and the costs associated with that are increased emergency usages, the stress on our public service folks, police, emergency. I really think that we need to take a pause. Let's get the right data, and I would please recommend that we not report this bill. Thank you so much.
Further speakers?
Madam Chair, members of the committee, just one more thing to know on the fiscal impact piece. My understanding from David and Senator Eben is that the bill currently has true expungement. So in the legislation we passed last year, it said expungement, but it was more sealing in practice.
Sure.
It was a more manageable cost for the Virginia State Police, which the General Assembly provided. My understanding is that the bill as drafted has its true expungement, so it may carry significant indeterminate costs for the Virginia State Police. I know you said you might conform it.
It's our intention to conform it to the language of what left judiciary with Senator Suravel's bill dealing with expungement and also with petitioning for resentencing. Yeah.
Okay. Okay.
Madam Chair, we would need a substitute to add in some additional amendments to make it fully conform.
Okay, so you're going to need to draft up a substitute. So we need to...
Can I just summarize, if I might?
Yes, go right ahead.
Just briefly, you heard about, some pretty serious scare tactics, but we made a policy decision last year that marijuana would be legal, and it's important that we have a product that's not laced with fentanyl and other things. I know some people are not a fan of regulation, but I think a highly regulated market is the way to control it. And I've never heard of the Centennial Institute, but there are other studies that show that drunken driving crashes go down in states where there's been cannabis legalization. And I'll have those for full committee if anyone wants them.
Okay, sounds good. Senator Norman?
Some of the points that have been raised just reaffirm my affirmation that this is a miserable piece of legislation. They're not scare tactics. There are some in the General Assembly that, with their professional hats on, are pretty conversant with these such situations. And I can guarantee you what is going to happen. The black market is going to increase the lacing of fentanyl in marijuana because that will give them a different product to promote. And that's not a scare tactic. That's absolute realism. DUIs have gone down. Part of the reason the DUIs have gone down is that they are still struggling to get an effective means to detect the presence of THC as impacting and impairing someone's driving. And I would say to Senator Evans, I'm really familiar with the research on it and what's going on, but I'm telling you on the street the way it is. I think it was a couple of years ago, I went out and spent 3 days in Denver. They had a symposium on Colorado's experience with marijuana, and I was amused because one of the prohibitions in Colorado at the time was that you couldn't smoke marijuana in public, and that this was a family protection, that we would, couldn't do it in public. And I'll never forget the first night a group of us were walking about 3 blocks from the hotel down the street and came to an intersection, and in all four corners, people were out there puffing a toke of marijuana, and it wasn't just 1 or 2, it's just a proliferation of it. The other thing is, I continue to think that I'm looking at the numbers down here, and maybe with the substitute, we can try to put an amendment on it, the distribution of revenues. Going back to my concern about CSBs, based upon the projected numbers at the high end, $60 million a year we're going to send to CSBs if these tax projections are right. $60 million in addition to everything else. And then the misnomer of the Cannabis Equity Reinvestment Fund would be $38 million, a portion of which is going to be reparations for people who were previously convicted of marijuana when it was against the law, not to mention the other distributions to minorities. It's just a miserable piece of legislation.
Senator Eben?
Not to create too much of a running debate, but what Senator Norman refers to as reparations includes scholarships for foster children and reentry services for people who are returning to the community, which I think are worthy causes for communities that have been damaged. And I'm open to talking to him further about the tax revenue that we codified last year, but I don't think that's part of this year's bill.
Well, we're going to need to, I'd like to take a vote before Senator, well, that's okay. Well, if we're about to wrap up, then we need a motion. Substitute's been moved and second. All in favor, say aye. Aye.
No. Abstain.
So there's 2.
You got a conflict.
No. What abstention? What is that vote? 4-2-1. 4-2-1.
I did have one more bill, Madam Chair.
Senator Eben?
This has to do with the parts that are used to make what are called ghost guns. It fixes a loophole. Manufacturers are required to put a serial number on finished firearms, but not on individual parts. So the bill would create a Class 5 felony for any person who manufactures, imports, sells, transfers, or possesses a firearm after removal of the parts other than a major component as defined in the bill is not detectable as a firearm by the types of detection devices commonly used at airports for screening. And it creates several Class 1 misdemeanors which are punishable as a Class 4 felony for a second or subsequent offense, making it unlawful to knowingly possess or transfer or purchase an unfinished frame or receiver unless the party is a federal firearms importer, manufacturer, or dealer, or the items are imprinted with the serial number. So this bill only addresses the unfinished frames and receivers. It does not capture currently put together guns. So if you have a hobby gun that you have already produced, that's not what it's about. It's about importing these devices available on the internet on sites like ghostgun.com into Virginia. They're particularly enticing, these weapons, for people who would otherwise not be able to pass a background check, such as domestic abusers, minors, violent felons. And we heard in committee about some horrific mass shootings using ghost guns, including a 2017, a man under prosecution for multiple crimes killed 6 people and injured 10 in Rancho Tehama Reserve, California, with 2 assault-style rifles he assembled using parts ordered online. Many others, including shootings of law enforcement and school shootings. Ghost guns put law enforcement personnel in significantly more dangerous and difficult situations with untraceable and undetectable weapons. And that's the bill.
Any questions of Senator Evan on the bill? Senator Edwards?
Move to report.
It's been moved and seconded that the bill be reported. All in favor, please designate aye.
Aye.
Noes have the same right. We have 1 no.
Chap says aye.
Okay. Thank you, Senator Evan. Just speaking to staff now, we have Senate Bill 122 and 127. Were both of those bills Senator Obenshane's bills?
Yes, I'm not sure, and we did give an option for folks to come tomorrow to full committee if they couldn't make it today, so unless
Okay.
someone's here for Senator Obenshane, we can take that over to tomorrow.
Okay, that'll be fine. Thank you. Well, then, there being no further business before the committee shall rise. Thank you, staff.